Hello everyone. In this video log I would clarify the concept of supranational law in the context of the European Union. In two groundbreaking rulings, the European Court of Justice has established the concept of supranational law in the European Union. That is the Van Gendt-Loos ruling and the COSTA ENEL ruling. In short, the European Court of Justice ruled in the Van Gendt-Loos ruling that European Union law is directly applicable, and in the COSTA ENEL ruling, the court ruled that European Union law is superior to domestic law. In the Van Gendt-Loos ruling, a Dutch transport company, Van Gendt-Loos, was confronted with an import tax that would now be forbidden in Article 30 of the TFEU. This case dates back to the early 60s. This tax was imposed by the Dutch government, and Van Gendt-Loos wanted to invoke this now Article 30 TFEU against the Dutch government to make sure that they do not have to pay this import tax. However, the Dutch government claimed that this provision was an agreement between countries and that a normal citizen or a company would not be able to invoke such a treaty article. However, the European Court of Justice ruled otherwise and ruled that when a European Union norm has direct effect, citizens should be able to invoke this norm, and in that sense it would be directly applicable. In general, a norm has direct effect when it is specific and clear enough to be applied by a court without a further need for any national legislation to be adopted. So when a European norm doesn't have that much margin of discretion, for instance because it is a prohibition to something, then it certainly has direct effect. In practice, therefore, the prohibition to all kinds of restrictions to trade have direct effect, such as Article 30 of the TFEU, but also Article 34 or Article 110. In the COSTA ENEL case, an Italian citizen was complaining about the fact that the Italian government had nationalized an electricity company. According to the Italian citizen, this was against European Union rules, basically rules on fair competition. According to the Italian government, that was irrelevant because it was the opinion of the Italian government that a European norm would never be able to replace a national rule, such as the nationalization of the electricity company. Where in that case, for other reasons, the citizen lost the case, the European Court of Justice was quite clear on one thing. A European norm was superior to a domestic norm and not the other way around. That means that European Union law is superior to Italian law. So, after watching this video log, I hope you've learned one of the most fundamental things of European Union law, that is the supranationality of European Union law. Thank you very much for watching, and if you want to see some more information, check www.drwernaart.com or like Dr. Wernaart at Facebook. That is www.facebook.com/drwernaart. Bye!